Thank you, everybody, for coming out tonight. We're going to get started. And I really appreciate your time to coming out. I really appreciate the panelists' time and wisdom that they're going to give us on the Safety Act. It's a great concern, and we want to let you know what is going to take place, what we can do to have input in its implementation, and just answer your questions in general about what the Safety Act, or as I call it, the Unsafe Act, means to public safety. And with that, I wanted first to introduce my staff. Micheline and Abby are here from our Springfield Events Group. And I have our staff here. I have Helen Mayfield, I have Raquel Sparrow, Lori McKee. They're the ones that do constituent services in both Quincy and Macomb office. And that's things that we want to tell you that we're there to help you with whatever issue you have with state government anytime, and they do a great job and are very helpful to me. So with that, I'll turn it over to Micheline.
At least 2 lawsuits now filed to stop part of the new Illinois criminal justice reform law known as the Safety Act from taking effect.
Illinois will be the first state in the nation to end cash bail starting next year, and that is sparking a concern that more criminals could be out on the street.
The Safety Act has entire categories of offenses where someone's danger to the community or a danger to others is not a factor. They can only be detained if they're a flight risk.
Businesses are already leaving the city of Chicago, some of them over safety concerns. Crime in the city is up 37%.
To threaten and to hurt innocent people, allow them back on the streets to do it again. That's the opposite of justice.
Okay, and I want to thank my panelists. I have Gary Farha, who's from the Adams County State's Attorney, Todd Eyler, who serves as an Assistant State's Attorney. We have our Quincy Police Chief, Adam Yates, and we have our Brown County Sheriff, Justin Oliver. And I also noticed that we have several judges here. I saw Judge Brenner, I saw Judge Adrian, and our Circuit Clerk, Lori Giesweiner, I saw come in as well. Our County Board Chairman, Kent Snyder, is here. I'm sure I'm overlooking some, but I appreciate everybody's concern and attention to this most important matter. Let me tell you about the Safety Act passed on January 13th, 2001 in the Senate at 5 o'clock a.m. That's right, a.m. It came over to the Senate from the House about 1 o'clock, and it had many changes in it. It's a 700-page bill. It is unique in that it did not go through the normal vetting process that any bill passed in the Illinois legislature goes through. It did not have committee hearings. It did not involve input from the parties concerned, such as law enforcement agencies. And as I said, it didn't have the regular committee hearings in the House and the Senate to be vetted, to let people know what was happening and have people give input as is appropriate. So that was certainly a big issue from the get-go, why it had to be done in the deep of night when nobody was aware, and why a bill of this magnitude that affects one of the government's most major purposes, public safety, would be done without law enforcement's input. It's kind of done under the guise of social justice reform. Now, a lot of people tell you bail, which means that a person is detained after committing or allegedly committing an offense, is held in jail or has to post a cash bond. And the social justice reform groups will tell you that they think it disadvantages people without any economic means, poor people, that they are inadvertently affected. And there's many arguments to the contrary, but that was basically the major premise of why you would pass a bill that would make it what we would term no bail. And it's truly modeled after what the city of Chicago has. And if you've watched what's happened in the city of Chicago with the crime running rampant, you would shake your head and say, why would we want to go to this length and do this procedure and policy that doesn't seem to be working whatsoever in the city of Chicago and has made the city far less safe. So people would say that misdemeanors and those of even a lesser drug offense should have a lower bond to be able to be released prior to trial, or they should have electronic monitoring. Well, what this bill does is it presumes that everyone who's allegedly commits an offense and goes through the booking process should be released. I mean, it just presumes that, puts a standard of proof on the state to prove that they're a danger to the public or a threat to public safety. And they have to, the prosecutors have to show evidence of willful flight, which is sometimes very often difficult, especially when you can't use prior times that they have failed to appear in court when they were supposed to. So, and then another part that I was, when I was reviewing today, if you're on electronic monitoring, if you go off the system and your electronic monitoring ceases to be working, you have to wait 48 hours to consider that person as fleeing and eluding the electronic monitor. That's a large window, and that's very troublesome in itself. But now I want to turn it over to the real experts that can go through and tell you what they consider the most heinous parts. It's a 700-page bill. There's many things in depth about it, but I'll let them give you an overall summary about what's going on.
Well, thank you very much, Senator Tracy. I do appreciate the opportunity to come and talk to you. Mostly my assistants have been going out and talking to public groups like this. I've been kind of staying on the sidelines. Todd Eyler, who was my first assistant, will be talking about the nuts and bolts. What I want to talk about, and I'm in a position where I can because this is my last go-around. I'm not running for re-election, so you're going to hear it right from the heart. This is a terrible bill. This should never have been passed, and if you came in here thinking this was a bad thing, it's worse than you even thought. In my 38 years of being in the criminal justice system, I've never seen anything like it. And I'm appalled that it got passed. I know Senator Tracy didn't have a darn thing to do with it getting passed. This was a direct result of a void in power and an opportunist of a group that came in and basically strung everybody along, and at the final hour, they passed this bill, and it's terrible. I can tell you that the State's Attorneys Association, which is 102 people, and when Darren Bailey tells us that it was 100 people against it, he's not lying. I was on those conference calls. It was, the state's attorneys were yelling and screaming, Democrat, Republican, it didn't matter. There were 2 counties, Cook County and Lake County, that were for it. Nobody else was for it. It has just the potential to be devastating to us. Once again, there's people that are trying to make the changes that would be helpful. Whether or not that happens, I don't know. What I do know is that 55 counties, state's attorneys, some sheriffs have joined in a lawsuit. Adams County has joined in that lawsuit. Absolutely. And it's going to be consolidated into Kankakee County. We think that's a favorable thing. Actually, all the lawyers have agreed to that. This matter hopefully will be done by the end of November, so we get some clarity. We believe it is unconstitutional on 2 or 3 different grounds. And a lot of veteran state's attorneys and their staffs have put a lot of hard work into it. They're very confident of the results that may happen. We are kept up at least on a weekly basis with Zoom calls and things. And everybody's, with every conviction they have, think this is awful for not only law enforcement, but for public safety for the people. There's things that are going to be no longer available to us. We just had somebody bring in 2 pounds of methamphetamine. Under this act, we wouldn't be able to detain them. They're just free to go. And this, you know, it's bad enough that Biden allows the borders to be open and people bring in drugs like crazy, but we've never seen people bringing in 2 pounds of methamphetamine. I've been involved with drugs for 25 years of drug enforcement, and I've never seen that type of thing. We used to get excited if we've got 5 grams of meth. That was a big case. That's 900 grams of methamphetamine brought in, and under this law, we couldn't do a darn thing. We'd have to release him. We could arrest him and then hope that he comes back, but he has no ties to Quincy. He's not going to get punished. This is ridiculous. So I just wanted to say that we do appreciate Judge Brenner's been working really hard on trying to get forms together and comply with the law, not because he likes it, but because that's his job. He has to comply with it. But we're not ready for its implementation. We're not ready for the ramifications of it. We're sure hopeful that the Supreme Court will say this is unconstitutional, and we're not going to have to deal with it. There, of the other 45 counties that have not joined in our lawsuit, that's because they are working on trying to get the legislation changed and passed to where it could be something that we could tolerate. The federal system uses a cashless bail system. You know, whether or not somebody has to put up money to get out of jail, that's not the important issue. The important issue is that we can detain dangerous people. We can detain people that have hurt other people, that have been violent towards other people, or are a terrible flight risk or things like that. Somebody comes down from Chicago, does something very bad in our community, and then just goes back to Chicago, and we have no way of finding them or prosecuting them. These are the things that are of concern. You know, hopefully things will get done, but, you know, the State's Attorneys Association in 2021 thought that we were going to get all this worked out. There were very veteran, wise prosecutors on the negotiating team, and they were promised everything under the sun, and it came down to 5 o'clock in the morning, and they got none of what they were promised in this bill. So it's terrible, and we got to do something about it.
And I'm the first assistant state's attorney, as Gary said. And the reason I'm over here is because I have a PowerPoint, and this is a forum for education. So I've got some slides that I want to show you because it's the actual law. There's a lot of talk about what is or what isn't and misinformation, and I want to show you some of the actual language. But before I get into that, what I also want to say is I want to comment on a couple things that both Gary and Senator Tracy said. Senator Tracy talked about the legislative history, and I would take it even a step further because she touched on it. But what makes it, I think, even worse is, and correct me if I'm wrong, Senator, when this House bill was first passed, it started off as a 7-page bill. And that 7-page bill was about voting rights for individuals that were being released from prison. The bill said that within 45 days, individuals being released from prison had to be given specific information on how and where to vote. It sat there for 2 years. It sat dead until what she described. In the middle of the night, they swooped in, and then they submitted 764 pages. You can come to your own conclusion as to why they did that in that manner. I'm not here to suggest or influence that, but I have my thoughts on that. But that's how it started. It started as a 7-page bill on giving people being released from prison information about where and how to vote. Gary touched on the number of state's attorneys that are opposed to this. He's absolutely right. There's 55 lawsuits that have been filed, and we, along with many other counties, are doing whatever we can. And ironically, a lot of those counties are Democratic counties in terms of the state's attorneys. This is not about politics from our standpoint. This is what it should be about, and that is public safety. Probably the two most outspoken state's attorneys against this bill are Democrats, Will County and Kankakee County. And they are leading the cause. They're on the litigation team. And again, they are Democrats. and they would be the first to tell you how bad this legislation is. This legislation is not just about doing away with cash bail. This right here is a slide, and I'll come back to it if either Chief Yates or Sheriff Oliver want it later. I'm not going to go into it, but these are just some of the things that this bill does as it relates to law enforcement. There are so many items that were included in this bill that affected and impacted law enforcement. And again, I'm not trying to influence anyone's thoughts. You can have your own thoughts as to what the agenda here was as it relates to law enforcement. But if you look at what these sections of the bill did and do to law enforcement, it's a shame. And I will let these gentlemen talk about that because that's their area. So this bill does abolish cash bail. That is exactly what it does. And anybody that suggests that it doesn't, they just don't know what's in it, or they're just flat out lying to you. The problem is that for the cases or the crimes that it does allow bail, there is a presumption of recognizance. And that, oh, this isn't working out like I thought. There it is. There's the statute that says the presumption. There's a presumption. So this starts with everybody should be released without posting a cash bail. After that, there is a particular section, and it is 725 ILCS 5/110-6.1 that lists different areas or types of crimes where bond or bail can be set. There's 6 of those areas. Those 6 areas, let's just start with the first one, because first of all, what you have to have is a forcible felony. And that forcible felony has to be punishable. It has to be non-mandatory prison. And that's important because that limits the number of cases that actually qualify. And you can see here I've got highlighted the only if and the and, because you've got to have the forcible felony. There cannot be eligible for a sentence to probation. And then the language down at the very bottom there that's underlined, the statute says that you have to have a specific, real, and present threat to any person. And we're going to come back to that in a moment, because here's some of the forcible felonies, or here's a problem. There are some forcible felonies that the statute says you can't issue a bond for, but they're probationable. So these right here, and this is one of the memes you've probably seen on social media, and one of the things that the governor and proponents of the bill say is misinformation. It's not misinformation, because those offenses right there, every one of those, you can obtain probation for that. And so therefore, it doesn't fit the second prong. It doesn't fit the and therefore, there's no bond. Yes, when the governor says this provision or this law does not set out specific crimes and say that they are non-bailable, you're right, they don't. But legislative history says if you include items in there that are, and you don't list anything that you don't list, it is not. So these crimes right here, as well as these crimes right here, every one of those, you are presumed to be released without posting bond. So if you look at those, burglary, robbery, aggravated battery, aggravated DUI, we've had situations where individuals are driving a car and they kill people. Under this law, because that is not a forcible felony that is punishable by prison only, because they are allowed to get probation, they cannot be held by bond. They cannot be held by bond because the second prong does not apply. Well, it just clicked on me again. The other thing, so that's the forcible felonies. In addition to the forcible felonies, you then have a series of crimes, and those are Section A2 here, and that is stalking and aggravated stalking. So if you're charged with stalking, there can be a bail set. The only if and must apply. What's important about this is you have to be able to show, we, the state, because the burden is on us to be able to hold anybody as a result of this law. And it's not a presumption it's not the presumption that we normally have right now of probable cause. We have to present evidence that shows by clear and convincing evidence, which is a much higher burden that these individuals should be held. So right here, we have to be able to present evidence that the denial of release is necessary to prevent fulfillment of the threat upon which the charge is based. So the problem with that in a stalking situation, what if somebody is stalking somebody, but they don't make a specific threat? If they just simply follow them around, we're never going to be able to meet that burden that is set forth in the last slide I just showed you. We're never going to be able to show this underlying language here because there's no specific threat that has been made. And that is a problem with that section. Even though we can hold people for stalking technically or arguably, if we can't meet that second hurdle there or jump that second hurdle, then we can't hold them. A3 is another section of cases where people could be held. It deals with domestic violence, domestic battery. And again, you've got the only if, the and that are highlighted here. It's not just that charge. We have to show that charge, and we have to show that there's an existing order of protection. And again, we have to be able to meet the burden of poses a real and present threat to the physical safety of any person or person. Now, without getting too far into the weeds, I'm going to show you a slide in a minute that almost every one of these sections right here, that language is in there as far as the real and present threat. But there's a section later in this statute that says something completely different and contradictory. So now when you hear people talk about the confusion of the statute and which one applies? And nobody knows because one, a court hasn't decided that yet, and two, the way the statute is written, because as Senator Tracy said, it wasn't properly vetted, there is confusion within the statute as to what standard applies, and that is problematic. Another section or set of crimes that somebody can be held on would be sex crimes. There's a lot of sex crimes, and they're all listed. They're not all listed here, but the list is long. This is the A5 is really the section of the statute that deals with sex crimes, and they can be held, or a bail can be set for those. But again, you have to present a real and present threat to the physical safety of any person or persons. The next section of crimes where a bond can be set is the firearm cases. And you probably can't, well, you can see that, but there's a lot of them. That's why it's so small. I apologize. But again, you've got the only if, you've got the and you've got the specifically identifiable person or persons. Now, I'm going to go back one clip because you can see that's different than the real and present threat to physical safety of any person or persons. But with the firearm, it's specifically identifiable person. And again, there's a difference there in the proof that is needed and the evidence that we have to present, and that is problematic. The next section of crimes is A7, and A7 is really kind of a catch-all, so I give them credit for putting in a catch-all, but here's the problem, and Senator Tracy touched on this when she talked about the willful flight. So you've probably heard people say, oh, all you proponents or opponents of this bill, you can always detain somebody because all you have to be able to do is prove that they're a risk flight. It's not that easy because this is what the statute says. If the person has a high likelihood or willful flight to avoid prosecution, they could be held. However, you have to know what the definition of willful flight is. And here's the definition of willful flight. It is planning or attempting to intentionally evade prosecution by concealing oneself. And I've highlighted in the yellow, as Senator Tracy noted, past failures to appear is not evidence or proof of this. So I ask you, absent somebody admitting to somebody that if they get out of jail, they're leaving town and they're never coming back, what evidence are we going to be able to present to a judge by clear and convincing evidence that they're a risk flight? They simply want to avoid or evade prosecution? Well, I don't know any defendant that walks in and says, please prosecute me. Here I am. That just doesn't, so I don't know. I honestly don't know, and nobody does. What's the evidence that we're supposed to have to prove this? When they're sitting in jail and they make jail calls and we monitor those jail calls and they tell their girlfriend or their boyfriend or a family member, hey, post bond, and as soon as you get me out of here, I'm gone. Well, there's evidence, but the only reason we have that evidence is because they're lodged and they're making a jail call, which tells them every time your call is being recorded, but they don't seem to remember that when they make certain admissions on the jail call. So that's the problem when somebody says that you can just present evidence for willful flight and hold them that way. I don't know how we're going to prove that. I honestly don't. And I don't know that most prosecutors do. The conflicting language that I was talking about, it shows the two, as you've already seen highlighted, some of those sections talk about a specific real and present threat to any person or the community, and there's the citation for that section. But then also in section E2, it says detention only shall be imposed when the defendant poses a real and present threat to the safety of a specific identifiable person or persons. So there's a difference there. What does that mean? Which standard applies? And I've cited a case there that says how we're supposed to interpret legislative confusion. And that's all good and well, but in the meantime, until one of these cases goes up on appeal and a court decides that, we're all left here holding the bag. So that's a real problem with the statute, and I just wanted to point out some of those languages because this is about educating people, and you hear all this talk about misinformation. You hear the memes where they say, the charges I showed earlier, the burglary and the kidnapping and the second degree, all that. The criticism is that, those people can be held. They can be held if we jump through all 2, 3, and sometimes 4 hoops to prove that. So if I make the rules, I'm more than likely always going to win the game, right? I mean, that's what they've done here. They've created a situation where they've created hurdle after hurdle, and it's higher every time. That's the problem with this, along with the fact that it was in the middle of the night when nobody was paying attention or didn't have time to vet this, and now here we are. One last thing, I've got so many slides here, but one last thing I want to show you is just some other considerations that this thing takes into, or doesn't take into account really. And with the lawsuits that have been filed, we touched on this in terms of the constitutionality of bail issues. There's no statement in the statute as to whether or not it's retroactive or not. So everybody sitting in jail right now come January 1, does this law apply to them? There's absolutely no statement in here that says whether it does or doesn't. State's attorneys are assuming that it is because we assume for the worst and hope for the best. Because if we don't assume the worst and we don't jump through certain hoops, a defense attorney is going to squawk and scream and yell and say my client ought to be out of jail or released from jail. So we have to assume that, even though the legislature didn't put information in there. Pretrial services, because people are either detained or they're not, and if they're not, then there's this pretrial services. Well, that's all good and well. The state has pretrial services, but they're not ready. And I don't think anybody in here is from the state and pretrial services, but they're not ready. They don't have this set up in all the counties across the state, even though this bill was passed 2 years ago, 1.5 years, 2 years ago. They're not ready. I don't know how some of these counties would possibly deal with pretrial services. We luckily, with our probation department, have a pretrial program set up. It's not consistent with what these guidelines require, but we at least have something to work with. It also changes the speedy trial. This law changes the speedy trial. If somebody's detained, speedy trial drops down to 90 days. Right now, speedy trial, if someone's in custody, is 120 days. So somebody gets arrested for murder, we gather up all the evidence, we send it to the crime lab. We've got to have all that processed, all that analyzed, and everything back into trial within 90 days. And if we don't, this law says that they are immediately released. So you realistically could have somebody charged with murder, initially held, and then because we don't have the analysis from the state crime lab within 90 days, that murderer or alleged murderer is going to be released. That is a reality. And when the governor and other individuals say that's not true, it is true. It absolutely is true. So I'm sure I've gone over my time, and I will now bow to Chief Yates. Do you guys want this slide up there? Because it talks about all those areas that affects law enforcement.
I'm not going to be able to see it anyway, so
Okay.
it doesn't matter to me.
All right.
First, good evening. I want to thank Senator Tracy and her staff for putting this event together. And I appreciate everyone that came out this evening to take part, to get a little bit of information, whether it's well received or not. It's information, and I think it's important that the community know what they can expect coming up in January. The job of any police department is to protect the citizens and the visitors to the community. We protect constitutional rights. We protect property. Over the years and the decades that we have been policing, we have come up with different issues that have, I guess in the mind of law enforcement professionals, stymied our abilities to do that. I was just talking to somebody not too long ago who mentioned the fact that when the Miranda decision was decided back decades ago, a number of police officers quit because they thought to themselves that they'd never be able to police again if we have to actually read defendants their rights before questioning them. Law enforcement is constantly dealing with different issues and roadblocks, court decisions that come up that make our jobs more difficult. This particular legislation goes above and beyond anything that we've ever seen in terms of making our jobs more difficult. I think part of the most disappointing aspect of this bill for me is if you look at the name, the Safety, Accountability, Fairness, and Equity Today Act, and the fact that it's often referred to as a police reform bill or a criminal justice reform bill, it has a very sad implication. And that implication is that in the state of Illinois, at least, that police officers are corrupt, that police officers are heavy-handed, and that police officers can't be trusted. And in order to fix that, we had to write a 700-plus page bill to put our law enforcement agencies and those hardworking men and women into check so that they can do the right thing. I'm here to tell you today that there's nothing even close to the truth when it comes to our law enforcement men and women and the hard work that they do to go out and protect our communities. But that's what this bill implies to me. And I think that's a shame. This bill deals with all kinds of different aspects of law enforcement, from equipment that we are allowed or not allowed to use and the methods in which we are allowed to use it, the levels of force that we can and can't use, and the decisions that we have to make in split seconds based on whether or not we're able to identify somebody and take them into custody later on. And now, the pretrial fairness portion of this bill, which means that one of the primary tools that we use in law enforcement, which is to arrest people and put them in jail, is no longer going to be a tool to us. I'll give you one specific example, and it's probably the most disturbing example of everything that's in this bill from the standpoint of law enforcement. We want to work with our citizens. We want to work with the community to try to solve problems. Some of you may have heard this story before, some of you may not. But come January 1st, law enforcement will no longer be allowed to take individuals into custody if they commit a Class C or Class B misdemeanor. Now, I'm not going to list the Class C and Class B misdemeanors for you, but I can tell you that trespassing is a Class B misdemeanor in the state of Illinois. So I'm going to tell you a story. You get up in the morning, it's summertime, you go out in your backyard and you look out in your swimming pool and there's someone in your swimming pool that you don't recognize. You go out in your backyard, you ask them what they're doing, they're saying, I'm just taking a dip. You tell them that they need to leave because they're trespassing and they're on your property and you no longer want them to be there. They refuse. So what do? You call the police. The officer shows up, the officer walks up to the individual and says, this is not your property, you've been asked to leave, you need to leave. And the individual says, I'm not going to leave. The officer says, well, then you're going to be arrested for trespassing. Next summer, the officer is then going to say, do you have your driver's license on you? And if the person says, yes, I do, then the officer will take that driver's license, write that individual a ticket, hand it to them, walk back out into the street, get in their car, and leave. Because we are not able to take that individual into custody come January 1st. I always tell people after I give you that analogy that our police officers are very good at what they do. They will certainly do everything they can for you to get that individual off of your property. But the way that this legislation is written, we face the potential, both individually as a police officer and collectively as a city, of being sued because we unlawfully detain someone for a crime that is no longer a custodial offense. And there's dozens of examples in this bill of different things that are going to take tools away from police officers and make our jobs more difficult. Usually, depending on whatever group I'm speaking to, the next question or the comment after the session is, well, at what point is someone just going to walk out into their backyard with a gun and deal with the problem themselves? And my response to that is exactly. Because if you expect to be able to call the police and you expect us to come solve your problem and we're not able to do that for you, we run the risk of individuals taking the law into their own hands and our communities actually being less safe because of this particular legislation. The initial legislation was passed. Law enforcement agencies, law enforcement associations had many concerns. Some of those concerns were addressed. I will say this: there is nobody that hates a bad cop more than a good cop. Bad cops give the rest of us a bad name and just make our lives difficult. There are certain aspects of this law that keep bad cops from going from department to department to department, because as soon as they're under investigation, they just resign and go get a job somewhere else. As a police leader, I think that's excellent. We want all the bad cops out of policing. This bill implies that every police officer in the state of Illinois is a bad cop, and we have to put things in place to keep us from going out and using excessive force, locking people up that don't need to be locked up, or a plethora of other things. And I think that's unfair. I think it's unfair to the brave men and women that put on their badge, gun, and vest every day and go to work. And I can tell you that it's having an adverse effect. You've heard it, and it's across the nation, but all police departments are shorthanded right now. No one wants to be a cop anymore. I've had conversations with people from other states, and I've said, look, you could come work in Quincy. We pay you almost double what you're making. And they say, nope, police reform. We're not going to deal with it. So this bill is having a tremendously negative effect on law enforcement, the morale of police officers in our state, and the overall safety that we're going to be able to provide to our communities. And that absolutely has us concerned. But what I will tell you is that we are going to continue to do everything that we can within the law to protect you, your property, to make sure that we are interacting with the community and that we were keeping our community safe, because that's our primary goal. Thank you.
I'm going to stand because I can't speak talking down, but my name is Justin Oliver. I'm Brown County Sheriff. I've got about 17 years on with Brown County. I'm going to take a little different approach than Chief Yates. I can tell you the reason I got into law enforcement was because I never knew what I was going to be doing when I showed up to work that day. There's something different every single day that I go to work. Something that I haven't seen, something that, I just learn new stuff all the time, and it was exciting to me, but with that kind of mindset, it's not really You know, law enforcement officers, we're used to change. We have to go to a law update class every year. I can tell you that the use of force guidelines from when I started the police academy, they've totally changed in the last 17 years. So we're used to change. We're used to having to do things different. We're used to having to serve the public different, changing how we, react, interact with people. It's not anything new. The things that bother me about this bill is that we have approached the sponsors of this bill. That I know the sheriffs in Illinois, several of the sheriffs, legislators, they've approached the sponsors and the authors of this bill and just asked to sit down with them and have a conversation with them about what we could do to make things better. I've been to several meetings at sheriff's associations over the last several months, and I was actually a little surprised. There's a lot of sheriffs in Illinois that are willing to make some changes, to try to make things better. There's no cash bail systems in New Jersey that are working right now for people. The state's attorneys, the law enforcement, everybody seems to be happy with how it's going. I'm not saying that's the route we need to go, but I think, in talking to Chief Yates and some of the other leaders in the state, I think we're all willing to try to work this out and try to do whatever is best for the public. To be able to serve the public, you got to be able to change. You got to be able to adapt, and it's just getting harder and harder to do that. I'm at the unfortunate part of my career where I can't just quit. I've got to stick it out. Brown County is a little different than Adams County. We're kind of used to not putting people in jail over there. I've got drug dealers over there that we've bought methamphetamine off of 5 or 6 times. We'll arrest them for the initial charge. They'll post bail. They get out. We buy off of them again. They go back to jail. They get out. And by the time it gets to the court system, we may have 5 or 6 buys on them. When I started in law enforcement, it was pretty much mandatory that we took everybody to jail for driving on a suspended license. When you arrest somebody for that, you give them a 21-day notice on a citation that they have court. Now we don't take anybody to jail for that. We write them a ticket and we release them. And by the time they get to their 21 days, sometimes we've cited them 4 or 5 times. But I look at this and I think we've already changed what we're doing so much. The people that were in jail 20 years ago are not in jail anymore. I've only got 4 people in jail in Brown County right now, and 3 of them, they're all violent crimes, and 3 of them they could be released January 1st. We got one guy right now that shot a police officer over there. We've got some sex cases. But in all of those cases, they're pretty much all people that have been in and out of the system 5 or 6 times. And they're probably going to be let go. So that concerns me, especially when we're not throwing very many people in jail. But I don't know what all the answers are. I know that we're willing to listen and we're willing to talk to legislators. We're willing to try to come up with a reasonable solution to this. But right now, it's just not happening. And my concern is, you know, they're not going to do anything until after the election. It's probably going to be 1st of December before any real conversations get had, and then we're going to have, you know, 20 days to try to learn 800 pages and figure out what we can do and what we can't do. And I don't know if that's possible. So I think it's going to be rough. We'll see how it goes, and hopefully things change. So that's all I got, Jill.
Well, thank you. And we do have some questions here that I want to get to. The first one was, it says, what changes would you like to see take place that would make the Safety Act fair and equitable, but yet not put the public at risk? There has been a bill filed by Senator Bennett that makes some changes to the bill. I don't think it goes nearly far enough. It does have some changes. However, it cannot be heard till veto session. Veto session is the week before Thanksgiving and the week after. And because it is veto session, you have to have a 3/5 majority to pass a bill. And so if that Senator Bennett's amendments would be taken up, it would have to have a 3/5 majority. I don't think there is a 3/5 majority right now. The Republicans are in the super minority in both houses, and I don't truthfully think that we would have it. But if it did pass, I still think what is left of the bill would be seriously flawed still. It makes some good changes, but not nearly enough. Because as we've gone through, there's so many aspects that need to be done. What I think needs to be done is the bill needs to be repealed and go at it again, start from scratch, because changing a bad bill by bits and pieces, as Todd Eyler pointed out, you have conflicting points that come up, and I just think we need to start over, involve law enforcement from the get-go. One of the representatives that I served with in the House, LaShawn Ford, said last week, we had to pass a bad bill because we couldn't get law enforcement to the table. I don't think that's fair. When you're not invited, you can't say you didn't come. So I don't see that as a good excuse to say we passed a really bad bill because we had to be extreme and now they'll come to the table. Well, we're willing to come to the table. I hear there's meetings going on involving a few in law enforcement. The Republicans have not been involved, and I don't think the major players in law enforcement have been involved at all. So that's my take. Does anybody else have anything else that you would want to say about making the changes?
I totally agree with you that I hope this bill is found unconstitutional. I think it needs to go to the people. I think there should be a referendum where the people decide. And honestly, I am sick and tired of Chicago being the main force for why we do things. We were perfectly good in Adams County with the system we had. It ran right. We have good judges, we have good prosecutors, we have excellent police officers, and stay out of it. You know, and unfortunately, over the years, I've been practicing 38 years. Over the years, I've seen more and more power go to the administrative courts of Illinois and this and that, and they take away the judges' powers. The judges should have discretion. I have discretion. Police officers have discretion. The judges should have discretion. So we got good judges, and we should let them be judges.
Thanks. I think sometimes we forget about that there are 3 branches of government, and it works very well that way for very good reason.
And that's one of the constitutional arguments that's being had, separation of powers. And that's an important.
The next question is, if someone is on my private property and I ask them to leave, will the police be able to remove them? I think Chief Yates covered that with his example pretty well, and that is problematic, is issuing a ticket may not be enough. So, how will this affect landlords and tenants that we are trying to evict? What about the loss of revenue from missing bail? It is a problem on the bail part of the missing revenue. That has been a very big part of revenue. When you flee, that bond is rescinded, and that's why you make it that way, is that you have an incentive to appear, so you don't lose what you've posted bail. As far as the landlords and the eviction,
I don't know that this bill changes anything as it relates to evictions, landlords, and or tenants, because you're going to have a dispute. You're going to have a disturbance that the police may be called to because there's a disagreement. But I don't know that it really changes anything. I mean, right now, when the police respond to that, correct me if I'm wrong, Chief, unless somebody has committed a crime that you're presented evidence with, if there's a dispute between a landlord and a tenant, whether somebody's entitled to possession or not, more times than not, I think you guys say that's a civil matter, which it is, and they have to deal with it themselves. Now, if people are beating on one another, that's a different story. But I don't know that this bill really changes the interaction between landlords and tenants.
It doesn't change those interactions, but what it does do, and this is another good point, is if you have a situation where someone's committing a disorderly conduct by raising their voice, yelling, just ultimately disturbing the peace, what this bill does is does not allow us to remove that person from that situation. That was one of the things that we relied upon, and our officers are very good at using discretion on whether or not somebody needs to be lodged in jail. But at least right now we have the ability to put them in handcuffs, put them in the back of a police car, take them to the police station, book them, and then release them on a ticket if that's what we want to do. In January, that ability goes away. So we're not allowed to handcuff them, put them in the police car, and take them away from the situation, and that's going to cause more problems.
and one other thing, the administrative duties of police officers will increase quite a bit. As I understand, there's like 4 more forms that you're going to have to fill out when you've arrested somebody, and it can have a negative impact of at some point, an officer may think, well, I just want to arrest this person. It's just not worth it to go through all the rigmarole and the forms, and you know they're sitting at their desks filling out forms rather than being out and looking for crime and policing. Another thing is the parts of it require more officers to serve subpoenas and that kind of thing, and so it does present a lot of administrative duties on the police department that weren't previously there.
Jill, there are also a number of different reports now that will be required, use of force reports, various things that we are now going to be mandated to basically provide to the state and the federal government, which is fine. We should be tracking use of force. We should be tracking the things that police officers are doing and the situations in which they are doing them, because what that does is provides good data so that we can provide our officers with better training. We can look for different technologies. We can figure these things out. But all of that stuff comes with an administrative cost, and someone's going to have to be able to sit down with all these forms and input all this information into a computer. And again, we're just talking about more work for police department employees.
And we also have more work to do because, and I am a big believer in body cams, and I know the chief is too, and the sheriff's department will be getting body cams. I think police and prosecutors used to fear them because you were afraid you weren't going to be able to get any prosecutions. It's obviously it helps us. So we have no problems with that, but now there may be 7 or 8 officers at a scene, and really only one person is dealing with that. The others are, but they're going to have to go through and send us all the body cams of every officer that was even possibly on that scene. Then we're going to have to go through those videos and see and make sure that everything that it possibly is relevant is turned over to the defense. That's going to be an extreme burden. And we don't have the funds to hire, nor do we have the ability to hire more prosecutors. I don't know what we're going to do. Maybe we can hire some retired police officers or something. I don't know, but it's going to be a tremendous burden on us. And there are lots of incidents that you have 6 or 7 police officers responding to a scene.
So can I just clarify, because they both touched on what I wanted to say. Gary's right in terms of that, everything he just said as far as what we're going to have to do. We do that now, just to be clear. As right now, what happens? So 8 o'clock tonight, somebody gets arrested. They get taken to jail. That officer will, depending upon how long the report will be, 1 to 2 page probable cause report. It's a short version of what happened. It's enough facts to give us information to be able to file charges tomorrow and then to present to the judge so the judge can make a probable cause finding, which is a lower burden than what I talked about earlier in terms of clear and convincing, to make a probable cause finding as to whether or not that person should remain detained or there was probable cause for detention, and then there would be bail set. Now, what is going to happen, because, so 8 o'clock tonight, that arrest is made. That report comes over, but that 1 to 2 page probable cause report that they do now, more than likely is not going to be enough. Because this statute says that if we, the state's attorney's office, wants to have this person detained, then we have to file a petition. And they have to be taken in front of a judge immediately or as soon as possible. Okay? That's up for debate. That's up for debate even between our judges here, I believe. Some judges think that means we have to have weekend court. Some judges say, no, that's not what that means. That, I think, is the discussion that's being had here as to whether or not somebody gets arrested on a Friday night or Saturday night. Do we have to have court on Sunday because the new statute says immediately, or can we wait until Monday? Right now, we have to get them. We have to get the reports in front of a judge for them to make a finding of probable cause within at least 48 hours. This statute says immediately. So what does immediately mean? First thing, next morning? If it's Saturday night, is it Sunday? Now, if we seek to have detention, we can ask for a continuance, and that continuance can be granted up to, I believe, 48 hours. But that's it. This statute also says that we get one bite at the apple. We can only file a petition for detention one time. In addition to that, we have to present evidence that meets the burden of clear and convincing. In addition to that, if we have a hearing, we have to turn over all the discovery. So now, when tonight there's an incident and they arrest somebody and they take them to jail and we have a 2-page report tomorrow for probable cause, we see the report, we file the charge, and we take it to a judge. After the first of the year, if this thing doesn't change, they're going to have to somehow upload the body camera and get it to us first thing in the morning. They're going to, if there's, as Gary said, if there's 5 officers in that on that call, we need a report from every one of them. We need body camera from every one of them. We need as much evidence as possible to be able to meet that clear and convincing evidence. So we're not just talking about paper and administrative burdens. We're talking about that plus more right then and there on the spot. So I agree with both, but it's even more pressing because of the way this statute reads. Sorry.
Yikes. Okay. How many sheriffs retired in anticipation of this bill taking effect? I don't know the exact number, but I do know there was a fair percentage.
I think it was 19.
19 of our 102. Okay.
It may be higher than that.
And as we heard Chief Yates say, it's had a drastic effect on just local police hiring and especially in Illinois. What can we do as individuals to stop this? Well, we have forms here. I mean, as we've talked about, there's litigation, which is very promising. I think there are some big constitutional concerns that hopefully the courts will address before January. I'm concerned because the courts sometimes are, just by the fact of the matter, are slow to be able to get a remedy. But Gary thinks that we're told now that the calendar says that maybe by the end of November. So let's hope that is one thing. And Adams County, as we said, has been part of that. Brown County is also part of it. Many other, as we said, 55 state's attorneys. This is a form we had out here today. And I was going to bring it up when we close, but there is a website called StopTheSafetyAct.com, which you can sign a petition. I forget how many people have already signed. It's in the thousands. Share this information with your friends, sign a petition, contact your elected officials. Randy Freeze and I are very much working on stopping this act, so you don't need to call us particularly. But tell your friends in other areas because we are going to be working very hard to stop this. And I know our news media will help get the word out that we had this, and we're doing everything we can. And I have seen in the last several years where if people join in, they've signed witness slips in committee and the like, it does have finally a tremendous impact because of the sheer numbers of the people against these things. And so we want to empower you to help empower us to try to get the word out that we are dead set against this, that we think it will have such a dramatic effect on public safety, and we've got to do what we can to try to stop it, to have it changed. Certainly, we're willing to have reforms, but not such that they damage public safety. Okay, the next question is, for law enforcement, crime has dramatically increased. In your opinion, what should be done to address this? Chief, I'll throw it over to you.
I guess my initial response would be repeal this bill. I think, and Judge Brenner and I have been making our rounds to the different civic groups to discuss this bill, and particularly the pre-trial fairness portion of it, so that everyone has an idea of what's coming in January. I still believe firmly that this is, the world is not going to stop spinning on January 1st. But what will happen, as does with any other change in law enforcement, is that as our alleged bad guys start figuring out that we can't take them into custody when they're trespassing in someone's backyard or when they're committing a disorderly conduct, then we will start seeing more issues. And as those issues and as people figure out that the rules have changed and that they're going to get away with more, I think we're going to start seeing more issues. So this obviously this legislation is certainly not any way for us to start lowering crime rates. This is certainly going to, if anything, it's going to enhance the issues that we deal with. It's going to make our jobs more difficult, and we're going to start seeing, we see, repeat offenders all the time now. COVID was a great example. When we went through COVID and we could not lodge people in jail, we started to see the tip of the iceberg of all of this, because we would arrest somebody for something and 30 to 45 minutes later we'd see him walking up Broadway. And it's very frustrating for our officers. This is just going to exponentially make that worse, and that is our concern.
We've already seen that, if I can just add. So some of the social justice reform that Senator Tracy talked about earlier, that was the backdrop to this, it started before this. The Bail Reform Act was passed in 2018. So in 2018, it was really the first step, maybe not the first step, but there was another step towards this way, or this agenda. In 2018, the law was changed to where crimes were categorized as Category A and Category B. Category B offenses, you received $30 a day credit towards your bail, if bail was set. And what we saw was immediately, because that law was passed and the legislative history and everything that went with that, we almost immediately saw lower bonds being set, because that was the push, that was the narrative, that was what they were suggesting should be done. Because as the story goes, if you spend 1 day in jail or 3 days in jail, it can have a very detrimental effect on you and your family. And that's one of the backdrops behind this. And that is that people should not be able to get out of jail or be held in jail because they can't afford it versus someone else. And I don't disagree with that. But the problem and the reality is when you just have a catch and release program, and we saw this during COVID, as Chief Yates said, and we saw it back in 2018, when individuals were being released much quicker and or almost immediately on some cases, they were right back out committing a crime, especially if it was drug-related or drug-induced. There was one gentleman in particular, 17 different cases he picked up in about a year and a half, because literally his crime, he would go out and steal, he'd go buy drugs, he'd do drugs, and then he'd get caught and get arrested again. And in that short time, he had 17 different cases pending. So when you have a catch and release type program, that's the reality of what you have. Because if you're dealing with druggies, they don't sit in jail long enough to dry up to go chase that next high, as it takes longer if they dry up. If you just arrest them, catch them and release them, they're still coming down off of that high, and they're more prone that much quicker to go do something and commit a crime. So he's absolutely right. We saw it during COVID, but it started before that in 2018.
So we have a question about whether or not there's going to be reluctance on the part of witnesses to come forward if they know that the person's going to be released. And I don't know if you all saw yesterday and today the accounts of this bill's sponsors and some advocates groups trumpeting this bill. I don't know how in the world that advocate groups that want to help domestic battery people or anybody else that has been victimized of violent crime could be talking about this bill being a good bill for them. I mean, they literally have not read the bill to take that type of attitude. There are defense attorneys here in Quincy that detest this bill because they live in this community. I just talked to one today, and the news media is wanting to get their slant or his slant on this question, and he did not want to even be interviewed because of the fact that he doesn't believe in the bill. Nobody that has any sense about them believes in this bill, I would say, here in Quincy. But yes, we're going to have trouble dealing with victims because they're going to be afraid of these people being out of jail, and we're going to have to come up with a solution. I don't know what it is, but we'll work on it and we'll do our best. But like I said, it is, I think we have loads of issues there.
Right, that's one of the things that we've talked about in our caucuses is the effect it will have on witnesses wanting to participate in the prosecution. The next question is, what is my legal right to protect myself from this law? Well, I do fear that many people will find themselves becoming perpetrators of crime, and we don't want that. We're a civilized society, and we live by laws and the process, and so it is worrisome, and hopefully we can get some answers. We use that trespass example all the time to point out the things, and as we've mentioned, the proponents of the bill come up with an excuse of, oh, we're just reading that wrong, and I don't think so. I don't think so at all. I think part of the bill says unless they present a clear threat. Well, I think it's going to be very difficult.
This law in and of itself does not change, I'll say defense law, self-defense. Self-defense of your person or self-defense of your property. But it's going to create a situation or more situations where it becomes an issue. I mean, Chief Yates talked about the scenario, but this, correct me if I'm wrong, guys, but this bill itself does not change that area of law, but it puts it in the forefront much more and much quicker in some situations.
The next question says, with the Democrats in control of both houses, what are we trying to do to stop this? If we can make some noise and do this kind of thing, let us know how to show our support. And again, like I say, sign the petition. That will help, and write a note to your state's attorney and tell them how much you appreciate them filing suit.
So the conference calls we've been on for the lawsuits that have been filed, all the state's attorneys are saying the same thing, that when they talk to their representatives and their senators, they're now feeling the heat. And the reason that they're feeling the heat is because of people like you that are educating yourselves and becoming more informed and having your voice heard. Here, we usually and typically don't have to worry about that. Luckily, we had Senator Tracy and Representative Freeze. They voted against this. So here, we don't have that issue. And here, I don't know of anybody, I'm sure there are some, but there are very few people here that I think are proud supporters of this bill. So I don't know that here's the issue, but letting everyone else know and being educated and informed and spreading the word is what's helpful, because when we're on these conference calls, the other state's attorneys say that these representatives in their areas are feeling the heat, and that just shows it's the power to the people and in the people. We saw it during COVID, we saw it with executive orders, and we're seeing it again here. So.
No, I agree. I definitely agree. Final question is, how much involvement did you and your colleagues have when the Safety Act was drafted? You wrote the question before I gave my summary, but there was no vetting. We had none. No input at all, and it's a very flawed process and abusive process because, as I said, it did not go through the proper channels, and there's rules against this, but sometimes they, as I'm very disappointed to see often in Springfield, they're tweaked, and that's how this is allowed to start, because as Todd mentioned, it started out as a very different bill, and then it was able to go through in lame duck session and was passed in the middle of the night. I'm concerned because we're going to have another lame duck session in January, and we have quite a few people that are leaving the legislature, so who knows what will happen in the middle of the night this coming lame duck. But this did happen. We're trying to stop it, get it changed, modified, amended, and changed before it becomes effective, and hopefully the courts will see it the way we do. And I, again, appreciate my panel. I appreciate all of you. I see Mayor Trope back there. I appreciate you coming, and each and every one of you that are concerned, pass the word to your neighbors and sign the petition. And we'll just keep you posted as things go along. So with that, we're finishing just a little bit, unless somebody else has another question that comes to mind real quick that on the subject. Well, again, thank
Senator,
you. Yes,
I'm just going to touch
ahead.
on one thing, because I think it's a good example. And the last question was, what kind of input have law enforcement or different associations? And as a member of the Illinois Chiefs Association, we rely on those associations and the Illinois Sheriff's Association to be our voice in Springfield to try to make sure that our rights and the things that we need done are being looked after. There's two really good examples in this bill that go to show that that absolutely did not happen. The first example is that resisting obstructing a peace officer, which is technically two crimes wrapped up into one. So if you get arrested for a crime and you resist, you can be charged with resisting, or you can obstruct a peace officer, and there's a number of ways to do that. They basically said that you couldn't arrest someone for resisting obstructing a peace officer without there being an underlying offense. So yeah, you can't get arrested for resisting unless there was something for us to arrest you for originally. And I agree with that. The problem is obstructing is in there as well. And the example that they used at the time was, there's a dead body laying in the front yard. We have crime scene tape up. Someone goes under the crime scene tape, goes over and starts spitting on the dead body. Normally we would arrest somebody for obstructing because they are obstructing our investigation. Well, the way that law was written, we could no longer arrest them for that. Now, that's been corrected in a trailer bill now that has come after the fact, but that's an example. If you had law enforcement sitting at the table when you're writing this bill, someone would have been like, hang on just a second. That doesn't make any sense. The other thing is use of tasers. Tasers are very popular now. Tasers have been proven over the years to save lives, because there's been plenty, even in the city of Quincy, plenty of opportunities where officers could have used deadly force on individuals and instead opted to use a taser and didn't have to use a firearm. And I commend them for that. The law said that you could not target the back of an individual with a taser. Axon, who makes tasers trains that the best place to shoot someone with a taser is in the back. It's completely counter to what the manufacturer says should be the use of that device in this initial legislation was illegal. And that's the kind of things that don't make sense. So, you know, again, we've had trailer bills that have corrected portions of this. We're thankful for that. But there's a lot that still needs to be done. There's a lot of ambiguity and confusion, and we really need to get this all worked out. And, you know, to say that law enforcement, you know, had input or didn't want to have input is absolute farce.
The use of body cameras is another example. The original bill said that they could not go back and look at their body camera when preparing their police report. We allow replay in the NFL and the NBA, but we don't allow law enforcement to look at their body camera to make sure that the way they remembered it was how it went down, or that they had all of the facts involved or included in the report. Because I can tell you, that's one way a defense attorney always attacks a police officer, if they don't include all of the information in your report. Because it goes like this: officer, you went to the academy, right? You were trained how to write a report, right? You were trained to put all of your information in the report that happened at the time, right? You made your report shortly after this incident, right? And if they don't put something in there, you can bet they're going to get blasted. But this bill did not allow them initially to go back and look at their body camera. Now, the reasoning is because they thought that they would edit it and change it and hide stuff. I mean, that's the reason. And anybody that suggests otherwise, I think, is kidding themselves. But that's another example. There's no way law enforcement would not have said, wait a minute, we need to be able to look at that.
Yes.
Chief Yates, you made a comment about the guy that's doing trespassing. You can't do anything. Okay, I'm an individual, you can't do anything. You said you could be sued or the city. But that liquor,
Right, yeah, I mean, if we arrested somebody and couldn't arrest them, then obviously the city could face a lawsuit, yes.
I'm an individual, now I take things in my own hand. Can that victim sue me?
I would direct you to your attorney. And you notice I didn't answer the question about defending yourself earlier too, right? Because that's not my place, because we would be the agency that would be investigating any use of force by a citizen. You know, if you have questions, again, I would suggest talking to an attorney. But yes, I mean, there you go.
Glenn, did you say, could the defendant sue you?
The victim, or yeah, the victim.
Yeah, they could, and you know they will. I mean,
You call him a victim. I don't think we want to call him a victim in this case.
I'm on the wrong side.
You just figure when you get done with them, they're a victim, and okay. I understand.
I think one of the most highlighted points was when Gary Farha said, this is the worst bill he's seen in his career. So, so with that, that's why I appreciate, was there another? Okay.
Here's a question up here. Chief Yates, you had talked about the private sector, and that was your description when you gave the incident with the trespassing.
Mm-hmm.
Does that law change as far as the business sector goes? So if somebody doesn't want to leave a business office, we're a mental health facility, a hospital, a school, is it different for federal buildings, city buildings, businesses, or are you just talking private sector?
No, it would be anywhere. And Todd or Gary could correct me on this, but I always use the pool, because if they come into your house, then that's a Class A misdemeanor, and that's a whole different matter, all right? But if you own a business and somebody in your business is being unruly, or they're yelling, or they're creating a disturbance, or you ask them to leave and they don't leave, that is still a Class B misdemeanor, and you would run into the exact same problem. We would show up, write them a ticket, and then they would remain in your business.
Ma'am, there's a lady back there.
I think she asked who wrote the bill.
Who wrote the bill? Well, it was the advocate groups, and I'm not even sure. I can't tell you. It was just put out.
If I could say, and again, I was told, the state's attorneys were told, because they were dealing with it, it was the Black Caucus of the General Assembly, plain and simple. They had power because there was a void of power. Speaker Madigan was out, and this was their first attempt at grabbing the power, and this is what we got, plain and simple.
John.
Todd, you had a list of law enforcement issues. The very first one was something about police complaints.
Yeah.
Against officers. What was that?
No, go ahead.
I say that for us, that's not really a concern. Basically, what that does is allows individuals to file anonymous complaints against officers for a police department. A lot of times we'd like to know who's filing a complaint, but at the Quincy Police Department, we investigate any complaint that we get, whether it has a name attached to it or whether it does not. In the past, there was somewhat of an affidavit on a police complaint that someone would have to sign that says basically I'm not filing a false police report when I'm making an accusation of misconduct against an officer. Those affidavits have had to been removed now, so that I don't know if you could still go after someone for making a false report against a police officer, but having them require a signature is no longer a thing. But at the Quincy Police Department, we haven't been doing that for 20 years. I mean, if somebody calls up or sends us an email and doesn't put their name on it and alleges misconduct, we're still going to investigate that misconduct and determine whether or not the officer had done anything wrong.
Yes.
Since this passed and J.B. Pritzker signed this into law in February of 21, how long is it, because I know Todd came to our Monday morning meeting and told us about it quite a while ago, but how long has the public or, been aware of this, and why does it seem just like right now everything's happening?
Well, actually, we had a town hall in this very facility, I want to say February or March, and I was joined by Senator Anderson, Senator McClure. We did statewide listening tours to make the public aware of the bill. And I think everybody thought January 23 was so far off, and surely we were going to fix it because it was so bad, but it didn't seem like it had the force. I mean, the Sheriff's Association, the Police Association, and the Police Chiefs Association, and the state's attorneys were really, I think everybody was just so aghast, they thought it would surely get corrected because it's not doable. It's just not workable. The mechanisms that it requires to be in place cannot feasibly be in place by that time. So, but we did try to publicize it, and I'm glad. That's why I'm so glad that you all are out tonight trying to gain information in your busy lives to really learn about this very important topic. So,
I think another part of the issue is that this bill has a number of different dates where certain things take effect. And we've already experienced that in law enforcement with a big change in our training mandates that took effect on July 1st. That doesn't matter to you because you don't have to worry about it. That was a big deal for us. Now with pretrial release, or the pretrial fairness portion of it that takes effect in January, that's going to affect everyone. And I think that's why you're hearing a lot about it now, is because that particular section is going to become law in January, and that's why we are working as different entities in the criminal justice system of making people aware of what's going on.
I also believe another part of that is there have been a lot of state's attorneys, because as we told you earlier, there were 55 that have filed suit. There are more that oppose this. There's 100 of 102 oppose this. But many of them have a seat at tables where they have been negotiating with legislatures, and they have been giving recommendations and suggestions. And for a long time, they believed that something would change. And as we're getting closer, they're realizing this is nothing but a stall tactic and it's not changing. And so now the call to arms, I think, has gone out because we're closer and it's more pressing. I mean, there are several state's attorneys in those phone calls that we have for the litigation. That's what they've said. They've said, we have been at this table with these legislators for a while now, and we've been negotiating, and that's why we don't want to be a part of the lawsuit, because they've told us if we file suit, we're kicking you off the table, away from the table. but we're getting there closer and closer every day and nothing's happening. So people are now realizing, hey, we have to do something, and thus the lawsuits that have been filed.
Is it normal for a bill to be passed, but take you almost 2 years to go into effect? Is that normal?
With a bill of this magnitude, that's not unusual at all. We sometimes have different dates to allow the mechanisms, and this one is just so complicated, the mechanisms still aren't there. So I also wanted to thank our host, John Wood Community College, for making this facility available. And with that, I'll just wrap it up. Thank you again, and be safe going home.